the first to know. Nsem-Pii TV.
Open one particular government agency and an officer that Ghana for do no ejidi say it is becoming useless in quote. You also mo juma omo ye sika ye di wura mu no, we are not getting value for money. The office of the special prosecutor. His Excellency Nana Addo Dankwa Akufo-Addo and established that office. From that time, we did budget allocation for the office. Any recoveries, office na ye in terms of Ghana sika, efa baby no entirely. All in all, the office of the special prosecutor so ba bontin be catch Ghana for say the mandate, the core mandate, in fact, a ban ye di jano no, or ye jumanti so big jina bontin kase. Juma or no, the office of the special prosecutor, it doesn't tally with respect to the kind of investment in that particular officer. Now, a propaganda and a Now, in all these instances, Ghana need to memunia unim a car bo the office of the special prosecutor and a Juma or yeno and obey the best judge with respect to Omujumedi. And you may your one you say. Rate of sermons be a free Accra High Court. The lawsuit no echo the office of the special prosecutor. Now damages a shemuno close to $30 million. $30 million. Now yan shan so say case ya kokoti. So busy was sued the office of the special prosecutor. It is an entity Ghana buying and the bohonka. Entino se kabiaba, the onus lies on the government of Ghana. Edi enebesi ama yasiu the office of the special prosecutor to the tune of close to $30 million in damages. Henfa and a lawsuit ni free. Ninyina is contained in documents adamenimwa making kind namidi in chiremu abremu. Ohe Accra High Court General Jurisdictional. The suit number is there. The plaintiff, a Strategic Mobilization Ghana Limited, a SML. Yes, SML. Ya na say Ghana buying HR Contractual or the Ghana Revenue Authority SML. And I sued the office of the special prosecutor. Now let's go through the statement of claim. As a plaintiff, a SML. Averse that it entered into a contract with the Ghana Revenue Authority to provide various services, including but not limited to transaction audit, external price verification, and real-time revenue assurance monitoring across the downstream petroleum sector, the upstream petroleum sector, and the solid minerals sector. Plaintiff says that all investment costs, operational costs, and incidental costs were borne wholly by the plaintiff and zero exposure cost to the Ghana Revenue Authority representing the government of Ghana. Plaintiff averse that since the commencement of its engagement with the Ghana Revenue Authority from June 2018 to date, the plaintiff has judiciously performed rightly and professionally all its obligation attributed to it under the contract. The Ghana Revenue Authority, on the other hand, has over the years certified, underline the word certified, all performance reports prior to the payment of the plaintiff's compensation as specified under the contract. Plaintiff states that on 10th of June 2025, the defendant, that is the Office of the Special Prosecutor's offices, entered its offices under a purported warrant and conducted a heavy militarized and intrusive search and seizure operation and took away the following. 1. Dell server, quantity 7. 2. HP all-in-one 24 inches, quantity 11. 3. HP all-in-one 27 inches, quantity 11. 4. Lenovo Think Center Neo 30A Generation 13 27 AIO system, quantity 2. 5. HP servers, quantity 5. 6. HP Elite Dex 800 G2 SFF, quantity 5. HP Pro Dex 400 G4 MT, quantities 2. HP Pro Dex 400 G6 MT, quantities 3. Dell Inspiron 16, quantity 1. Hikvision NVR, quantity 1. HP Color Laser MLB M4 800, quantity 1. HP Sun Storage, quantity 2. MacBook Air, quantity 1. Durabook Tablet, quantity 1. Apple iPad, quantity 1. External hard drives, quantity 11. Dell laptops, quantity 2. HP laptops, quantity 2. SML Nova Mineral Scale, quantity 5. SML Nova Mineral Analyzer, quantity 4. Dell XPS, quantity 1. MacBook Pro 1. Lenovo laptop 1. Dell Durabook 1. SML Nova Mineral Scale printers 3. SML Nova Mineral Analyzer printer 3. Mobile phone Infinix 2. Mobile phone cards 2. Pen drives 1. Dell all-in-one 1. Forming the backbone of the nationwide petroleum monitoring system, transaction audit, and solid minerals monitoring. Plaintiff averts that its central server infrastructure contains uniquely engineered firmware and software designed to authenticate the operational technology devices at the media access control, address level, preventing unauthorized access, data manipulation, industrial espionage, and signal spoofing for downstream petroleum, upstream petroleum, and solid minerals. Plaintiff states further that these firmware, software, and security configurations store deposit-specific gold sites, floating production, storage and offloading, and device identifiers tailored to each site stated. These components are not generic and cannot be replaced if off-the-shelf hardware, firmware, and software. Plaintiff averts that the seizure of the items listed in paragraph 6 caused immediate collapse of the secure communication chain linking all 25 depots to the central data system, resulting in total cessation of real-time data flow. Mame, enfam hana minchirimu na tiase. SML, a company Ghana by contracting in 2018, say ye petrol na yetu downstream, upstream, keep records, do a ye to sika ye nya, and all these records. And omuchirim say, officers if the office of the special prosecutor, bowra o makache, say omo ye investigation, omo say purported, because utwa inu so abon se sti ya no omo hunu krata bia no omo de kire sapal by for no bowra ho no se sanwa. And omuchirim say omo se sanwa no since 10th of June no. That time when cancel contract no. A seize on operations in my fede. No munya real-time data say they na air coso ewo Ghana yen downstream ni upstream petroleum sector nyina no afi na SML and to mean track bio. Ti na Ghana yen to mean kire said barrels of oil, crude oil, do say in the free ha, do say all 25 depots. There was no real-time information with respect to the Anekoso. The person which ha. Nina eye anamontua the officers from the office of the special prosecutor. Ebetu ye to us or say plenty further states that deposit authentication protocols, FPSO sites, and mining sites, source to server communication layers, calibration libraries, and the proprietary firmware and software became permanently invalidated following the abrupt removal and uprooting and seizure of our equipment, rendering our entire system inoperable. Plenty of others that due to the bespoke nature of the firmware and software, the seized servers cannot be redeployed without triggering widespread authentication conflict and system failure. Plenty of others that in order not to breach its contractual obligation with Ghana Revenue Authority, it immediately communicated to GRE on the system downtime as a result of the abrupt removal, uprooting, and seizure of computerized environmental defendant firmwares. Plaintiff states that the defendant unlawfully interfered with the plaintiff's electronic records and computer systems in a manner that completely destroyed the integrity of national petroleum monitoring infrastructure, solid minerals monitoring, and transaction audit. Plaintiff states that the SCADA system deployed for national petroleum monitoring infrastructure, solid minerals monitoring, and transaction audit qualifies as critical information infrastructure, and the defendant's manner of uprooting the plaintiff's SCADA system endangered national revenue systems without safeguards. Plaintiff further avers that the defendant unlawfully interfered with computer systems by taking both primary servers and backup servers without applying required technical and proportionality standards or preservation procedures. Plaintiff states that investigative actions involving computerized systems are by law required to preserve system functionality and prevent data loss. However, the defendant's militarized actions caused a total system collapse. Plaintiff states that the seizure of its computer data was not carried out by trained or qualified forensic personnel, contrary to the requirement that such operations must be done to minimize operational disruption and preserve electronic evidence. Plaintiff avers that instead of conducting forensic imaging or cloning, which preserves business continuity, the defendant forcibly uprooted physical hardware, destroying the plaintiff's operational capacity nationwide. Plaintiff states that the defendant unlawfully accused, assessed, and uprooted systems containing business-sensitive, proprietary, and third-party protected data without implementing necessary safeguards. Plaintiff avers that no measures were employed to prevent data breaches during the seizure, leading to exposure and corruption of protected information. Plaintiff states that electronic evidence must be preserved with integrity, but the defendant's militarized seizure, including disabling CCTV and refusing oversight, compromised chain of custody. Plaintiff therefore reconstructed the entire technological environment at a substantial cost of $28,850,125.50. Breakdown of Sesi Kanuni. Cost of replacement of service and firewall equipment $144,400.05. Software replacement and reprogramming $28,400,599.85. Installation and testing $200,125.60. Re-establishment of secure connectivity with client system $105,000. Total no $28,850,125.50, which is a little close to $30 million. Plaintiff states that after the restoration of its operation, as stated in the preceding paragraph, it performed and submitted all backlog reports to the Ghana Revenue Authority. Plaintiff avers that the defendant mishandling of the seized computerized environment, including service, firmware, firewalls, supervisory control and data acquisition SCADA components, violated both national and international recognized standards on chain of custody, forensic imaging, evidence preservation, and the handling of digital systems. Plaintiff states that the seizure and handling procedures were not executed to preserve evidence, but form part of a preconceived plan to inflict operational harm, compromise property systems, and destroy the plaintiff's technical environment. Plaintiff states that the defendant's conduct was premeditated, as evidenced by the deliberate removal of the plaintiff's CCTV system during the raid, a calculated act intended to eliminate video evidence of the unprofessional, unlawful, and irregular manner in which the operation was carried out. Plaintiff contends that the conduct of the defendant on 10th of June 2025 amount to unlawful seizure of property, abuse of statutory power, and a gross violation of the privacy rights of the plaintiff. Wherefore, the plaintiff claims against the defendant as follows. A declaration that the defendant's detention of service, scan storage, SML Nova Mineral Analyzer, SML Nova Mineral Scale, CCTV systems, computers, laptops, external hard drives, mobile phones, printers belonging to the plaintiff is unlawful. B. An order directing the defendant to return the SML Nova Mineral Analyzer, SML Nova Mineral Scale, CCTV systems, computers, laptops, external hard drives, mobile phones, printers, currently in the unlawful possession of the defendant to the plaintiff. C. An order directing the defendant to pay to the plaintiff special damages in the sum of $28,850,125,000.50, being the cost of the service, SAN storage, installation and programming at all the 25 depot communication layers, transaction audit suite, petroleum upstream supervisory control and data acquisition system, and solid mineral suite to the central server. General damages in the sum of 20 million Ghana cedis against the defendant for the unlawful detention of SML items. E. An order directing the defendant to indemnify the plaintiff against any liabilities from third parties on account of the defendant's unlawful detention of its equipment. F. Cost, including legal fees on a full indemnity basis. G. Any other relief as this honorable court may grant Boyo law firm. And apart from the close to $30 million, no Obasan claim 20 million cedis. Yeah, no, yeah, damages. Close to $30 million in India. A service your market of fro. Any programming on my year for fro, any BB on my year for fro. And no, any yes are close to $30 million. And a damages caused on a 20 million Ghana cedis. The way any the official lawsuit a free SML called the Office of the Special Prosecutor because so already now on be now so many say enye lawful nti almost as na no temper with the CCTV said the be ya omunya video evidence but Ghana mremu no say investigate ade ye digital ya wokwan ya faso a well trained forensic officers any more carry out said the be ya obewie no information data bibia be intact but we dey gidi no mo de buy access Nsem-Pii ti ye hwe se asem high court ebe frɛ na ye hunu se de enema ebesi aye. It is going to be a very very interesting case because any aye ka say the government of Ghana a cancel contractor on a strategic management limited from SML with regards to downstream and upstream petroleum products nsem any jumedi ahodo aneka ho na SML edi the Ghana Revenue Authority.